Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English. On Thursday at 5:30 p.m. EST with attorney Chankar Ratnini. And on Friday at 6 p.m. EST with attorney Bhanu Virendra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at us@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to readyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, readyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The readyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is H1B cap and H1B process. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. And before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hi, Ms. Reddy, how are you doing?
I'm good, Tony. How are you?
Very well, thank you. And may I say that you're glowing today. White
Thank
suits.
you, thank you. Thank you. I don't wear white much, but thank you.
Right. So, Ms. Reddy, do we have any updates or should we just get into the topic right away?
Let's get into the topic.
Right. So, Ms. Reddy, the first question is speculative employment allowed while filing an H1?
Yes. So speculative employment, that's a big topic. Simply because there's been a lot of discussion online and offline about consulting companies filing H1s without putting any purchase orders or in-client letters, vendor letters, etc. There's a backstory to this, and that is basically that there was a lawsuit filed, ITServe versus Cessna in 2020, and they won the lawsuit, as a result of which the judge said that invalidated a certain things, and USCIS then issued a policy memo, and basically they said that you cannot ask for especially in the context, all this is mainly in the context of a consulting companies scenario, computer consulting, IT consulting company scenario, where they bring in employers and place them at different client sites. This could apply to, of course, any kind of consulting scenario. So the court basically invalidated the RFEs or invalidated the fact that USCIS was asking for information about the employee-employee relationship when these consulting companies were filing H1s. They were basically saying, USCIS was sending out RFEs saying that there is no employer-employee relationship because these people are not actually working at the employer work site, they are working at a different work site. So they're, if you look at the common law definition of employer, they're not actually supervising and reviewing their work. The other thing that USCIS was asking for was contracts and itineraries to show that the employer had worked for the employee for the entire duration of the H1. So if you're filing a H1 for 3 years, they wanted to see contracts, work orders, POs of where you're placing these candidates for the next 3 years, and they wanted to see detailed itineraries. So basically what happened, this conglomerate of companies got together, it's called ITServe, and this organization filed a lawsuit saying that these requirements were unlawful because the law doesn't require, Immigration and Nationality Act doesn't require them, so it's burdensome for employers, etc., etc. The court agreed, and USCIS issued a memo in 2020, or June 2020, basically saying that they were rescinding the previous policy memo about employer-employee relationship that was actually issued in 2010. based on which they were asking these questions about employer-employee relationship. And they rescinded the 2018 memo, which allowed USCIS to ask for contracts and itineraries, etc. As a basis of which there seems to be an opinion that since they cannot ask for contracts and itineraries, you can file speculatively, meaning you can file without any contracts and itineraries at all. That you can file a H1 with just the forms and not have to explain where the person will work or what they'll actually, where they'll be working or which project they'll be working for. But in the same memo, USCIS has said that they can still, there is a topic on speculative employment, and USCIS has said that though they're not looking for evidence of specific day-to-day assignments for the entire period of time, there is another requirement which says that in order to qualify for a H1, the employer should have an offer of bona fide employment for specialty work. So under this bona fide employment rule, which is in the INA, USCIS can ask for what work the beneficiary will do. So in the context of a consulting company, they can then require the employer to show contracts or a letter or a purchase order, end client letter, vendor letter, as to show that they have enough specialty occupation work. They don't require a purchase order for the entire 3 years like they used to before, but they're saying they can still require employers to show what work they'll be doing. If it's consulting, then you have to have a consulting gig for your employee before you hire. Earlier, before all these memos and when H1s were much easier, I would say before 2010, we would just file petitions without really any supporting documents. And this was called speculative employment, really, because what employers were doing is they were bringing in people on a H1, putting them on the payroll, and there were benching laws at that time. And as long as you paid them when they were not working or in a non-productive status, you could bring them on a H1 and then you could look for work for them. And there could be a gap in their gigs between clients. So as long as you paid them, that was fine. So USCIS has said that it has not debunked the notion of speculative employment, so that's still a thing. And it's talked about benching a little bit, and they said that benching is allowed the officers should look at this on a case-to-case basis, and it's as long as they are being paid, and all the other requirements are met. The officer, they're not automatically out of status if they're in a non-productive status. So this is something that I wanted to bring to everyone's attention, this memo from 2020 June, just to remind them as to what USCIS, as per their memo, what their new policy is when filing your H1B cases, especially now with cap season upon us, where maximum H1s are filed. I think it's important to review what present USCIS policy is. It's not to say that you can't file H1B skeleton petitions. I mean, it's fine. You might be able to file a few and not get an RFE and therefore may not have an issue. But if you're going to file several petitions and all of them skeleton petitions without any information as to where your employee will work, then you might, if you get RFEs, you might not have a leg to stand on unless you're willing to again litigate. And tell USCIS that their June 2020 policy or memo is also unlawful. So that's my position on speculative employment.
Right. That was actually quite informative and elaborate, Ms. Reddy, and thank you for the wealth that you really provide with information. And my next question is, what about duplicate registrations of H1B, Ms. Reddy? Are they allowed? And how the USCIS is enforcing it?
So duplicate registrations are allowed, yes or no? Allowed in certain circumstances and not allowed in certain circumstances. So H1B duplicate registrations, while the beneficiary can file duplicate registrations for themselves through different employers, the employer cannot file a duplicate registration for the same employee. So if you have an employee, whatever, called Jack, you can't file duplicate 5 registrations for Jack. You can only file one registration, but Jack can file registrations through several companies, A, B, C, D. The other caveat with reference to duplicate registrations is if USCIS finds out that ABCD these companies have filed registration for Jack, but they're actually done it in collusion with each other with the attempt to get Jack a better chance at winning the lottery, then they can, that is not allowed, and they can penalize you for that. So the question is, of course, how will they enforce it, and what they're doing to enforce this issue of collusion while filing duplicate registrations. And, they've been sending out notice of intent to deny, notice of intent to revoke after the H1 is getting approved. They're sending out RFEs. Last year they did that. And in these RFEs or NOIRs, NOIDs, what they're saying is that, your company has filed for Jack, and A, B, C, D, other companies have also filed for Jack. And we're also noticing that 30% of your filings, you file for the same people. So, and we also noticed that one of the companies that you filed for is your vendor who has provided you with the vendor letter. So there are many ways they can show collusion. One is, of course, if you have the same office and you're both filing for the same people, they'll say that there is collusion. If there's a relationship between the different companies, say your husband has one company, wife has another company, that could be collusion because there's obviously a relationship between the two companies. If there's sister concerns, meaning having same owners, or if, like they said in that RFE, one company is the vendor to another company and both companies are filing to increase the chances of Jack to get within the lottery. So that's collusion and that's not allowed. So when you get these RFEs, it's not necessary that there is collusion just because USCIS is saying it. It could be that it was innocent, and I'll tell you why. A lot of companies get resumes from the same recruiters, from the same source, or they could get resumes from online. There are a lot of recruiting companies in Hyderabad, Mumbai, Delhi, in these big cities, and they give out hundreds of applications to, their clients. So it's possible that you're working off the same list and you're selecting the same candidates. If you have 100, maybe you've selected 30 out of those 100 and all the companies selected the same 30, right? So that's not necessary that one company knows each other. It could be that there's another explanation. So always look into it. Take the opinion of an attorney as to how to respond if you do get those RFEs, especially if you do not know these other companies that filed. So that's my take on duplicate filings.
Right. And what about cap gap, Ms. Reddy? Could you explain to us what a cap gap is, and the cap gap extension, the eligibility for it, and the whole scenario of cap gap? Because that's where we actually ended on in our last show. And you said that cap gap is like a whole different topic.
Right. So let's talk about cap gap. And this is also very relevant now with, again, I wanted to remind our viewers today is March 1st. So the H1B registrations have opened up and we've been filing registrations since 12 noon. That's when it opened up. So if you have registrations, please go ahead and file them or contact your legal representative, your attorney to file your registrations. So the reason why cap gap is so important is because it deals with cap cases. So all those change of status cases from an F1 to a H1, and those are the maximum number of cases that are filed really, F1 to H1 cases during the cap. So currently regulations allow certain students with a pending or an approved cap subject H1 petition to remain in F1 status during that gap period. So the gap period is basically the time that the person's status expires on F1 and the October 1st, which is the date that the H1B petition start date, because we're filing 6 months in advance. The fiscal year opens up on October 1st, so we can only put a start date of October 1st for all our cap cases. And say if you, at the time of filing, you may have been on an F1, but you may have, that F1 may have expired in the summer, in June or July. And so there's a gap between July and October 1st when the H1 is actually going to start. So they created this gap law, which basically allows you to fill the gap or extend your status during that gap period. So whatever your status was at the time of filing, that status will continue until the time, until September 30th, basically. So that's your cap law. Now, with reference to eligibility for this cap extension, obviously not everyone is eligible. So in order to be eligible for a cap, you have to timely file a change of status from F1 to H1, and the start date on the H1 should be October 1st. So basically, even though an F1 has a DS, meaning the duration of status, there's no end date for an F1. As long as you're on an F1 status, you are in duration of status. So what happens is, as long as you are in some kind of F1 status, that is, you could be on an F1 OPT, you could be in your 60 days grace period after your OPT is completed or before it started and your course is completed, you have a 60 days grace period. You could be in that status. Whatever status you're in, as long as you're in a valid F1 status, you could be in post-OPT STEM status. So whatever status it is, until September 30th, that status continues, right? So that's something that to keep in mind. So it's important that if the student's H1 petition is approved, the student's cap extension of status, we have to note that it continues only until September 30th. So the cap extension of status will automatically terminate, of course, if the student's H1B petition is denied, withdrawn, revoked, or rejected, or of course if the registration is not selected. So this is very important to note. So if you file for a cap, if you're trying to get that cap extension, you file for a H1, but your H1 gets denied, or your employer withdraws it, or your employer withdraws the change of status part of the application, even though the H1B petition is still alive, or if it is revoked by USCIS through to some fraud, etc., or if it is denied by USCIS, then you are not eligible for the cap. You become ineligible for the cap. And then what happens is you have a 60 days grace period to either go back to an F1 or to leave the country. So you have a 60 days grace period. You're not left in the lurch, but they have provided a 60 days grace period for you to get back into status in case one of these things happen. So certain people are eligible for cap. Once you become eligible, you may become ineligible if certain things happen. That's what we're trying to say. Now we have to also remember that F1 students who have entered the 60 days grace period are not authorized to work. If a H1B cap subject petition is filed, properly filed for a person who has entered a 60-day grace period, the student will receive an automatic extension of F1 status, but not an extension of the authorization to work, right? So 60 days grace period doesn't allow you to work. This applies if you're in your 60 days grace period before you started your H1, and that's the basis for your F1, or if the H1 was consequently withdrawn or denied and you fall into a 60 days grace period, whatever the means of getting that 60 days grace period, you're not allowed to work during that period. There are some people who are not qualified for this cap extension. So if the person, the F1 student who do not qualify for cap extension and whose period of authorized stay expires before October 1st, If that is the case, and if you're not qualified for this cap gap extension because you're not in status as of the date of filing, or you are beyond your 60 days grace period and you do not file a change of status, then they have to leave the country and go outside the country and then apply for a H1 outside the country for consular processing. You can still continue your H1, but you'll have to leave or file a change of status. And if you leave, then you'll have to convert your H1 to consular processing, and then you can get your H1 while you're outside the country and come back on a H1B visa by going to the nearest consulate.
Right.
So once again, if you don't qualify for cap gap, then you have to leave. Because if you stay, then you will be out of status and then you will not be able to file a H1 or continue with your H1 application. Because the consulate will then say that you have accrued periods of unlawful presence, and that's a problem. Now, what is the proof of continuing status while on cap gap? There's no real petition that has to be filed with USCIS when you're in the cap gap period. It's an automatic extension of status. But if you do need, if you're working and you are work authorized, and if you need a work authorization document to extend the I-9, your employer might require this, then what you have to do is provide a copy of the H1B petition that was filed along with the filing proof such as UPS or FedEx, certified mail receipt, etc., to your DSO, to your student DSO, your designated student officer. Then the DSO will issue an updated I-20. And that updated I-20 will show that your OPT is extended until June 1st, right? Then once you get a receipt, so they're basically presuming that you'll get a receipt. If you file in April, that you'll get the receipt by June 1st at least, or sooner. So June 1st is enough time. So they're only giving you until June 1st. And then after June 1st, the DSO will have to ask you for the actual receipt notice because you would have received the receipt notice by then. And then the DSO will extend the I-20 in CVIS until October 1st. So this is what to do to get proof of continued status. You don't really need it, but if you need it for employment, then you have to ask your DSO to extend the I-20 and submit the extended I-20 to your employer. Now, what happens with denied H1B petitions? If a H1B petition filed for a student with a cap gap extension gets denied, rejected, or revoked, we talked about this, kind of talked about it previously.
Right.
Or withdrawn, the student will have, again, the 60-day grace period, like we said, to depart the United States or file for a change of status. 60 days grace period does not apply to a student whose change of status request is denied due to a status violation. Remember this. So if the change of status happens, denial happens because you have not maintained your status, or USCIS is alleging status violation or misrepresentation or fraud, then you don't get the benefit of that 60 days grace period. After your H1 gets denied, you have to leave immediately. Same thing if your H1B gets withdrawn or revoked after it gets approved. If it is revoked for the same reason, status violation, fraud, or misrepresentation, again, you don't get the 60 days grace period, you have to leave immediately. So that's the exception for that 60 days grace period that you get. Now, the other frequently asked question is, can I travel during the cap gap extension period? And yes, you can travel during the cap gap extension period. And as long as the student's H1B petition and a request for change of status has been approved. So if the case is already approved, then you can travel. Your H1 does not start until October 1st, so you can leave and come back on an F1 because you are maintaining F1 status based on cap gap. The student seeks readmission before their H1B employment begins, so that's before October 1st. And the student is otherwise admissible, meaning that they don't have any other issues whereby they would be deemed inadmissible at the port of entry. However, if that student travels outside the US, while the H1B petition and the change of status request remain pending, the request for change of status will be considered abandoned. So that's why they're saying you can travel while your H1 after your H1B is approved, but if you travel while it's still pending, then there's another issue that happens here. Any change of status requests, if you travel, they are deemed to be abandoned. So what will happen then is that the H1 will then be approved for consular processing, and the change of status request will be denied. And remember, if the change of status request is denied, there's no more cap gap. The cap gap rule doesn't apply to you, so there's no benefit to you from the cap gap. Okay, so that's something to remember. So never travel while the H1B is pending. You can travel after it's approved. Now, what happens with the STEM OPT extensions? If you have an extension that you have to file STEM OPT extension during your cap gap, can you do that? Yes, you can. You can file the OPT extension during that artificial cap gap period. You're allowed to do that because it's considered to be authorized stay. So they allow you to do that. Also, we can touch upon very quickly because I know we're kind of running out of time and we haven't covered all our topics, which we will do next week. But what are your unemployment limits? A lot of people ask with reference to how much period of unemployment is allowed on OPT. So with reference to initial OPT, post-completion OPT, that is the OPT that you get after your master's, which is for 1 year, you're allowed 90 days of unemployment. But remember, under this, employment can be voluntary, so you don't have to be paid for the entire period. Under your STEM OPT 24-month OPT period, you're allowed 60 days of unemployment. During this time, you actually have to be paid during the entire period. But 60 days, you don't have to be employed. They give you that break time to find a job. So that's something that people keep asking me. So I thought I'll mention that.
Right.
There might be some issues with the start date because CVIS has to be updated. And this is something that's done by the DSOs. And sometimes when it is not updated properly, then the student can go out of status. So it's important to contact your DSO, make sure they update your OPT until October 1st, because sometimes the OPT is issued only until September 30th. So there's some confusion there because H1 starts on October 1st. So they should be able to fix that by contacting the CVIS help desk. Yes, the DSO will fix it. So something to keep in mind.
Right. So with that, Ms. Reddy, we do come to the end of this session. We do have, I think, a lot more to discuss again from this, and we'll continue that in our next session. Thank you always for sharing the best of information with us, Ms. Reddy. It's a privilege to host you.
Thank you. Take care. Bye.
You too. You're watching Sakshi TV Live. This is Torni. Thank you.